much for joining us today. Thank you for being here with us. My name is Emily Cook, and I serve as the General Counsel for Texas Right to Life. It was the intention of Chris's mother, Evelyn Kelly, to be here this morning, but because of everything that has happened recently at the hospital, she understandably does not want to leave Chris's side. Additionally, we have some other organizations not represented on the agenda that are here with us this morning to show support and solidarity for Chris Dunn, Empower Texans, and Grassroots America, We the People. We're here this morning because of a case that has sparked national attention. A 46-year-old man at Houston Methodist Hospital is in a battle to save his life. Chris Dunn has served Texas and his nation as an EMT in the Harris County Sheriff's Office and as a Homeland Security employee. Pursuant to a draconian Texas law which sanctions involuntary euthanasia, Chris Dunn and his mother, Evelyn Kelly, are fighting to save his life and have the hospital not end Chris's life prematurely. This case is not about how ill Chris Dunn is. At the heart of Chris Dunn's court challenge lies the question, who decides? Who gets to decide whether Chris's life is worth living? Who gets to decide whether Chris's quality of life is meaningful enough to warrant medical treatment? The answer about who decides Chris's life is not Chris. That decision is not left up to Chris. That decision is not left up to his mother or those that know him best. Texas state law allows for a group of people who have never even met Chris before entering the hospital to decide what kind of life would Chris want to lead? What kind of world and quality of life would Chris want to have? And then allows that same group of individuals to decide whether he will receive medical treatment and make medical decisions on Chris's behalf. Like all Texans, Chris Dunn should be the one to direct his medical treatment. And in cases where patients are unable to speak for themselves, those decisions should be left up to the friends and the family who know Chris, who know patients and love them the best. If we allow a group of persons to decide whose life is worth living and whose life is not worth living, where does that stop? Does needing dialysis render a patient too sick for treatment? Does requiring a wheelchair make a person's life not useful enough to warrant treating for infections? Is reaching the age of 65 too old to be of use to society anymore and making them ineligible to receive medical treatment? What you will hear from speakers today is the reality of the dangerous nature of this Texas state law and the manner in which this law gives open access to a group of unidentified people in profit-based hospital societies to be both final judge and jury of a person's right to life. At the end, we will answer questions. I have a brief Q&A questions with the media present today, but first I'd like to turn the podium over to Dave Welch, President of the U.S. Pastors Council.
Thank you, and my name is Reverend Dave Welch, representing the U.S. Pastor Council. We're an interdenominational, interracial coalition of pastors throughout greater Houston and Texas and beyond. Do all the good you can, by all the means you can, in all the places you can, at all the times you can, to all the people you can, as long as ever you can. So spoke Reverend John Wesley, the founder of the Methodist Church, denomination by which this hospital itself is named. And he was simply articulating the fundamental virtues and values of Christ himself and the nature by which a hospital, in giving care to those that are hurting and sick, ought to operate. This is not rocket science. The question here is, do we value human life? Is every person of immeasurable value, or are they not? What has happened at Houston Methodist Hospital? There's a fox in the hen house. There's cancer in the body. Somewhere in the process of decision making of who is to be provided fundamental care of diagnosis and treatment, it's broken. And in a nation that has revered life, revered freedom, and revered faith, every person is of value, this cannot be tolerated.
No.
We must stand and we must change not only the policies that govern these kinds of decisions, so this could not happen again to any family. But I will simply say this to Houston Methodist Hospital: change your mind, change your policies, or change your name. Thank you.
My name is Joe Nixon, and I'm an attorney that's been hired by Chris and his mother, Evelyn Kelly. We brought the lawsuit that has stopped the panel from fulfilling its stated goal of terminating life-sustaining care. It is not trite to say that everyone has a right, a due process right of life, liberty, and the pursuit of happiness. And that life may not be terminated without due process. In Texas, however, the Health and Human Safety Code has a provision that allows a nameless, faceless committee to decide that the hospital will stop life-sustaining treatment. And as you saw in this case, for a person who is awake, alert, communicative, and wants to live, and in fact praying to live, I do not understand why Texas has a statute that says you may walk up to a patient who is praying to live and say, "This is your last moment." We have the right to terminate life-sustaining care. We have challenged the constitutionality of the statute because we believe it is abhorrent to the basic principles of the United States Constitution and the Texas Constitution. We believe that every person has a right to live from beginning to their natural end. This statute does not allow an opportunity for review of the decision. The statute does not allow an opportunity for appeal of the decision to a court of law. It does not allow the patient to have an advocate present on their behalf to advocate for life. It does not allow the patient to present different evidence to the committee. There's no record of the committee to review. There's no published criteria of any committee. This is not a situation that is unique to Methodist, but every hospital in the state may utilize the same statutory provision to make the same nameless, faceless decision. In the end, criminals on death row have more rights than patients in a Texas hospital seeking to defend their life.
Yes.
Thank you.
Good morning, everybody. My name is Jeremy Newman. I'm the Policy Director with the Texas Homeschool Coalition. We approach this issue very much from a parental rights and family rights perspective. And I'd like to speak to all of the people who are watching and listening today to make sure that they understand that the effects of this issue are not distant and they're not ambiguous in the way that they affect their own family. That if you have parents, if you have children, if you have loved ones who are in a Texas hospital, this law applies to you. And the way that that works is that the law waits until the moment when you or your loved one is the most vulnerable, and then it removes its protection from you. From our perspective, the right of someone to protect themselves and their family is perhaps the most fundamental aspect of family rights and human rights in general. And so the fact that Texas, of all states, has a law that allows the hospital to decide over the decisions of the patient or the patient's family, whether that patient can live or die, is about as medieval as anything that you can imagine. And so what I would like to point out is the fact that, as mentioned before, the family is the one who has no rights in this position. So we can talk all day about whether the hospital or the family has the right to make this decision, but in the end, only one person's life is at stake in this situation, and that's the patient. So I would like everyone to stop and think for a minute. If this is your family member, if this is your child, if this is your loved one in a Texas hospital, how does that change your own opinion about the way that this law affects you and your family? The reality is that there is nothing except, there is no right more fundamental than your own life or the life of your family or your loved one. And so the fact that you have an inability to protect that because the Texas law waits for your patient to become most vulnerable and then removes its protections from you and your family is something that all of us should realize is not 21st century, and it's certainly not Christian, it's certainly not conservative. So the reality is that we live in a day and age where life is not respected and where the hospital now has the rights over the rights of your family to decide whether your patient lives or dies, regardless of whether that patient is able to communicate. This is not, there's another point that has to be made here. This is not a situation where the patient is necessarily incapacitated in the sense that they cannot communicate what they want. That the patient can be fully able to communicate and the hospital still has the ability to walk in and remove life-sustaining treatment from that patient. If somebody else walked into that hospital and removed the life-sustaining treatment and killed that patient, we would call it murder. But when the hospital does it, for some reason, it's okay. And so I would submit to everybody here that this is a very simple issue. It's a very weighty issue, but it's a very simple issue. Only one person's life is at stake, and that's the patient's life. And that should make this decision very clear to us. Thank you.
Good morning, my name is Emily Horn, and I'm also with Texas Right to Life. And as Emily Cook mentioned already, the law allows for the same treatment of anyone in a Texas hospital. So unfortunately, Chris's case is not unique. In fact, we are currently assisting 4 other families in Texas hospitals that are going through the exact same process, who are facing denial of treatment from various hospitals. And unfortunately, we've actually helped over 250 families navigate the horrific reality of suddenly having to face a hospital seeking to remove your life-sustaining care against your wishes. Texas Right to Life has always done whatever we can to ensure that we can help them in any way possible, but unfortunately this law makes it very difficult to protect the lives of Texas patients. While Chris's situation is not unique, it is personal. It's personal to his family, to our staff, and to thousands of others around the state and nation who have been praying daily for his recovery. And it's personal to Chris, who you saw clearly and consciously on the video pray for his life as he understood what was happening. He clearly communicated that he does want to live. Chris is not unlike many patients we help in that he is not in a coma. He is not unconscious, as you saw in the video. I visited with Chris and his mother several times now, and just the other day, I walked into the hospital and his eyes were closed, but as I would greet any other hospital patient, I just said, "Hi, Chris," and he opened his eyes, and although his hands were tied to his bed, he waved at me. And it's interesting to me to see his hands tied to his bed as such a visual representation that he is clearly alert. You would not need to tie the hands of someone that is unconscious or in a coma. This situation, while personal to many people, is the most personal to his family. And I'm very thankful that his sister Holly is here to join us today, and she wishes to thank you all and issue a statement from her family. So this is Holly Gomez, Chris' sister.
Thanks. Hi, my name is Holly Gomez. I am Chris's younger sister. First and foremost, I just want to thank, on behalf of our family, everyone that has prayed for Chris, shared his story, sent cards, donated, done everything that you guys have done. We could never thank you enough for what y'all have done to support us and to share his story. One thing that I want to share with you about Chris is that he's just an ordinary person. He helped raise me. I remember as, you know, a little girl, we used to watch Johnny Carson together at night. And so I think it's important for people to understand that he's my brother, but he's also your brother. He could be your child. It could be your son laying in that bed, or your brother, or your uncle. And no one should have the right to come in and say that this person is futile, that they don't deserve to live. Because I know, being in the medical field for a short time, machines don't keep you alive. Machines help sustain your life. And so when your time is gone, then you will go, whether you're on a machine or not. And so Methodist Hospital or any other hospital around this country should not have the right to come in and say, we're done, and we're gonna pull the plug on you. And so I just want to end with one thought for people to just think about. If George Bush were laying in that bed, do you think that they would pull the plug on him? Do you think that it would even be brought to his family to consider, to say, we're done with him and we're going to go ahead and pull the plug in 10 days? So I just want y'all to think about that. Thank you.
Jim Graham, the president of Texas Right to Life. Thanks for coming. I'd also like to thank Jonathan Sines, his coalition, for being here as well. First, I want to thank Holly and Evelyn for your moral goodness in defending Chris Dunn. And I also want to thank them for their courage in fighting an institution that has net assets worth $4 billion, and for having the fortitude to challenge the constitutionality of a state law that has caused a fundamental paradigm shift in healthcare. What we are seeing is a shift from patient autonomy to institutional autonomy, whereby the institutional autonomy always supersedes the will of the patient or his surrogate. And this is unfortunately the worst law in America. And I would add that the doctors who remove treatment against the will of a patient have complete legal immunity. There is no legal recourse, no matter what happens in this process. And while this law is the worst law in America, there is a movement to make the Texas model the national model. And this horrific situation that exists in our Texas statutes must be stopped. Texas Right to Life has been fighting this law since 2005, and this will be one of our top legislative priorities, as I think it will be of every group behind me, to make sure that this atrocity ends. We must rectify this situation immediately. And with that, I think we will field questions.
I guess this would be for Joe Nixon. Could you explain first of all, the health situation, his exact health situation, and also, do you have any politicians who are helping?
I haven't been to visit Chris in the last couple of days, but I understand that, he's sick, but I understand that he's hanging in.
I mean, what was the original problem?
The original problem was unknown. There was a CAT scan that was done. It determined that there was a mass on his pancreas, and then he was, after that was determined, my understanding is that he went to apply for a gold card, an insurance card, so that he could then go have a biopsy. And while waiting for that card to be approved, he became sicker. His mother called for an ambulance. He was taken to Bayshore Hospital in Pasadena, and then subsequently transferred to Memphis, where there has not been any further diagnosis or testing done to determine what is the exact problem. But we all know that he's very sick. Now, other politicians, I mean, that's a legislative solution. I've been brought in on behalf of Chris and his mother to obtain a legal solution. And it is appropriate for a court to examine this law based upon constitutional principles and determine whether or not this law comports with the state and the United States constitutions. If it does not, the law should be struck down. In which case, that not just this hospital, but no hospital in the state should be allowed to utilize this law in the state.
How long has he been in the hospital?
How long has he been? 8 weeks. And so, on December, I met with Chris several times. On December 2nd, I just happened to was visiting with his mom downstairs, and Jim Graham and another partner of my law firm and I were visiting with Evelyn, and Evelyn suggested, well, let's just go up and talk to Chris. So we did. Chris was alert and wanting to communicate. So I pulled out my phone, handed it to Jim, and Jim took the video that you saw. That was 10 days after the date the hospital said we are going to terminate his life. So Chris is alive today and alert and communicative. And the hospital made this decision on November 13th, more than a month ago. And I just don't know how you go into a person and say, your time is over.
What does the hospital say? What is their reason?
I'd like to speak for 1 second about your politician question.
Okay.
This draconian law is not new to the Texas political world. Texas Right to Life has session after session been at the Capitol, present, hollering about how awful this statute is in the lives of hospitalized, sick Texas patients. We're hoping that the continued media coverage of this issue will lead Republican and Democrat lawmakers at the state level to take drastic action, the action that we have been asking for session after session that would have saved Chris's life, would not have put Evelyn and Holly and Chris in the situation that they are now if the changes advocated by Texas Right to Life had been accomplished last session, the session before last. And so I want to encourage everyone. One of the reasons for Evelyn and Holly and their help is by raising awareness of this issue to make sure other families do not go through the same process.
I guess one thing I'm wondering is, what does the hospital say? How do they justify? Is it an insurance thing? Some kind of cap? Is it they determine that there's no further procedure possible, or what do they?
One thing I think
give up?
it's very important for everybody here not to put words in the mouth of the hospital, and not to describe to them motivations of which we aren't sure. So I don't think, I'm not going to answer that question. I'm not his lawyer, but I don't know what the hospital's motivation is, other than what we know in the letters that they've written.
What does Chris's father say about this?
It is my understanding, and I've never spoken to Chris's father, but it's my understanding in my communications with Ms. Kelly is that his father is supportive of the hospital's decision.
Can you tell us what the hospital said to the family without speaking for the hospital? When they said they were going to stop care, for what reason did they say?
The reason stated in the form letter is that the remainder of his life is shielded. So, No.
We had a meeting with Chris's father's side of the family and our side of the family, and they basically told us that Chris's care is futile, that there's nothing they can do. They said they've done all the curative care that they could do. Our argument was that there was no curative care done, there was care to stabilize him, which they did an amazing job at, outside of doing the tracheostomy, which never happened. But there was no care to cure him. Nothing was ever done to say, this is your diagnosis and this is how we're going to go forward with helping to fix the problem. So, Chris had probably been in the hospital for maybe 2.5 weeks, and they had said that his care was futile, and that they were going to have the ethics committee meeting with the hospital providers and some of the people that worked for the hospital. And then they would give us 10 days after that to either transfer him or they would end care. So,
What would be the transfer process? Is that an option still?
at this point, I don't think that Chris is, I mean, I'm not a doctor, obviously, but just in our opinion, he's not healthy enough at this point anymore to transfer.
The transfer process, the burden is put on the family to find the transfer. In cases that Texas Right would like to see, the burden is on the family in this time of despair to figure out how to get medical records, to call hospitals, to know what kind of hospitals to call, and when there's a breakdown of communication between the family and the hospital, there's, you know, it proves almost impossible to effectuate a transfer. Legally, the burden of the current statute puts the transfer process, that burden, on the hospital. But in reality, in practicality, it falls to the family to pick up that slack. And that is where Texas Rights Life gets called in these cases to try to help effectuate a transfer.
Has a court determined who Chris's legal guardian is?
It's still,
Not yet.
Not yet.
Joe?
No. The court, the hospital originally applied for guardianship, claiming that Chris didn't have the authority to hire him, even though you saw in the video that he did, and his mother sure did. So that challenge is in probate court, and so we filed an application on behalf of his mother saying she should be the guardian, or that he doesn't need one. So, and now the earliest date we have been able to get, even for an independent medical exam, is January 6th.
And he might not. I mean, his condition is...
The only legal holiday between now and the end of the year under state statute is Christmas.
Got it.
And one of the things that I wanted to add about as far as the guardianship issue goes is, first and foremost, we think that Chris should have right to say what he wants. He's still alert. He's not in a coma. He's not brain dead or anything like that. But the second problem that we've run into with the guardianship thing is that the hospital itself has filed for guardianship over Chris. And now, I personally think that's a huge conflict of interest when we know already what they want to do is to end care.
Yes.
So, and another thing that we also wanted to let everyone know is that Chris has lived with my mom and stayed with my mom. She raised him as a, you know, when his parents were divorced, he's always lived with her. And so we feel that if anyone should get guardianship, it should be her.
I heard someone say there's something like 250 cases. I don't know if that was statewide or nationwide, since statewide, I guess, for this long. And you're assisting for the families. Is this the first time that there's been sort of a challenge to this?
A challenge to the law?
To check, you know, to the situation, to the law.
So we've helped, it's a state law, and so we've helped about 250 families or over 250 families at various different levels depending on what their situation is. And yes, we do have 4 cases right now. I believe this is the first time there's been a constitutional challenge, but this is not the first case like this.
And we only know the cases of patients and families who know that Texas Rights Life is here to help them and who call us. So there are untold numbers of cases that this 046 process, there's no state mandating reporting, so hospitals do not have to report to a state agency, the Department of Health or anything like that, about how many times they invoke this 046 process. And so we don't actually have an accurate number of how many times the statute has been invoked and to end the life of patients prematurely. We only know those cases in which land in our office.
Can you talk a little bit about what the law actually says, the statute, what it gives the hospital a right to do and what it doesn't have a right to do?
Absolutely. The statute is found in Chapter 166.046 of the Texas Health and Safety Code. And basically, if a hospital, if a doctor, if there's a disagreement between a physician and the family on treatment, on what next steps of treatment there can be, whether to continue life-sustaining treatment, including dialysis, and we've had cases where blood pressure stabilizers were the treatment at issue. The doctor, the physician, gives a notice to the family saying a member, a group of hospital-based folks are going to come together and we're going to talk about what to do in your loved one's case, or in your case, as it is Chris's. We're going to talk about and let you know whether we decide with the doctor to withdraw treatment or whether we decide with you to continue treatment. And that notice is only required for 48 hours before this meeting of the hospital personnel occurs. The patient's only given 48 hours notice. This ethics committee consultation is convened 9 times out of 10 from what we have, with issues that we've been involved in. The physician, the hospital agrees with their own physician to withdraw treatment. Then, after that decision is rendered by the ethics committee, second notice is given to the family that says, you have 10 days, we've made this decision to withdraw treatment, you have 10 days to transfer your loved one to another facility. At the end of 10 days, all treatment will be removed.
But about this ethics committee, I mean, aren't these other doctors? I mean, what are the standards to be on the committee?
There are no statutory standards. You can have a hospital social worker, you can have someone down the hall. There are no qualifications from state law to guide. Those policies are adopted each by individual hospitals, and so you, as well as invocation of the 046 process to begin with. So in Texas, you just hope, cross your fingers, that something drastic happens, you end up in a favorable hospital.
Is Chris guaranteed to stay in this hospital and continue receiving treatment until January 6th?
We were successful in getting an order in place in the district court that ordered the hospital to continue life-sustaining treatment until the issue of guardianship has been resolved.
Okay.
Is there a written record of what happens if you do, by chance, this ethics meeting?
There is no written requirement for recording of decisions made by the ethics committee.
And then what can a family of a patient do then after the committee comes to that decision? Can they request a rehearing, or I mean, what do they do?
There is no further recourse at the hospital level, according to state statute. The only recourse a family could have is to try to find a transfer to another facility, or if they know that this is an option, they're able to hire an attorney and file for an extension of time in a state court. And what that does is would prolong the 10 days, giving some more time to the family. But there's no review of how the committee came to that decision. There's no review of the patient's health. There's no review of why the decision was made in the first place.
Well, under the statute, does anyone have a right to speak on the patient's behalf at the hearing?
You said the right? No.
What about the patient? Does the patient have a right to speak on his own behalf, assuming that he even can, physically?
Realistically, the letter is supposed to state that the patient can attend, or their surrogate can attend if they want the ethics committee hearing. That's about all the level of protection. It doesn't guarantee that they will be heard. Doesn't guarantee. We've been in cases where speaking on their behalf has been denied in the ethics committee.
Do you know who is on that committee? Is it public? The ethics committee?
As you've been told, there are no criteria. We don't know who's on the committee. We don't know when qualifications, backgrounds. We don't know what they consider. It can change. They can put new people on, take people off. There's no public role or examination of who's on these committees. And it varies from hospital to hospital.
If there are no other questions, then we will wrap up. I want to thank you so much on behalf of Chris Dunn, on behalf of Evelyn, on behalf of Holly, and all of the organizations you see represented here today. Thank you for taking time out of your Christmas week to come hear about this tragic situation. Thank you.
Thank you.
Bishop Atlanta is nice to meet you. Let's go. Pleasure meeting you, Bishop Atlanta. The minister is crying. Reverend David Walsh. And some of our